Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the trial of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi on 5 June 2025, the trial panel issued a revised scheduling order regarding the next steps in the case. The judges ordered the defense to submit their joint request for dismissal of charges under Rule 130 by 12 June. After this, the Specialist Prosecutor's Office has until 7 July to respond. The trial panel also indicated that it plans to decide on the defense's joint request for dismissal of charges in the week of 14 July. Should the trial panel deny the defense's motion in whole or in part, the Victims' Counsel is ordered to be ready to start calling witnesses on 16 July. Each of the defense teams should also notify the panel on 16 July about whether they plan to present evidence and call witnesses. More details are available in the trial panel revised scheduling order on the KSC website. In the same case, Victims' Counsel informed the court that one of the participating victims in this case has passed away. The victim was admitted to participate in the proceedings as a result of having suffered mental harm as an indirect victim of arbitrary arrest, detention, cruel treatment, murder, and enforced disappearance. On 4 June 2025, the trial panel admitted an additional victim to participate in the proceedings. The participating victim will be included in the existing group of victims, represented by the same Victims' Counsel. The panel noted in its decision that the deadline for submitting applications for victims' participation in this case had passed on 15 February 2023. However, finding good cause, the panel accepted this application. On 5 June 2025, the trial panel rejected a request by the Veseli defense to appeal an earlier decision by the trial panel to admit into evidence documents from the Dukagini zone. The panel stated that it had conducted a careful assessment of each item in question. On 11 June, public versions of provisional release decisions for Jakub Krasniqi, Kadri Veseli, and Recep Selimi were issued. The trial panel denied the requests in separate decisions, finding that there continues to be a risk that the accused may obstruct the progress of proceedings and/or commit further crimes, considering that Victims' Counsel will submit a list of potential witnesses for its case, and the accused will therefore be exposed to sensitive information. In view of the panel, the rationale it applied in relation to prosecution witnesses applies equally to the witnesses to be called by Victims' Counsel. The panel further noted that the risk of interference may also exist in relation to witnesses the defense may choose to call, and that witnesses who have already testified in this case and other witnesses relevant to the proceedings could be subject to interference or retaliation. In the case of Hashim Thaçi, Izni Kilay, Bashkim Smakai, Fadil Fazliu, and Haridin Kuchi, the pretrial judge issued a number of decisions related to pretrial detention last week. Under the KSC law, someone can only be detained before their trial under certain circumstances, including if there is a risk that they will flee justice or interfere with witnesses. As a reminder, this case is distinct from the trial in which Mr. Thaçi and 3 others are accused of war crimes and crimes against humanity. This case, which is still in the pre-trial phase, involves accusations from the prosecution that Mr. Thaçi and others unlawfully interfered with the testimony of witnesses in Mr. Thachi's war crimes trial. On 5th June, in separate decisions, the pretrial judge found that there are articulable grounds to believe that Hashim Thachi, Izni Kilay, Bashkim Smakai, and Fadil Fazliu may flee, obstruct the progress of the proceedings, or commit further offenses, and that these risks cannot be sufficiently mitigated by any proposed or additional conditions for release. In considering the risk that Mr. Thachi may obstruct proceedings, the judge referred to the allegations that Mr. Thachi coordinated with 3 distinct groups, of which he was the leader, to interfere with the testimony of prosecution witnesses in Mr. Thachi's ongoing war crimes trial, and that he instructed others to unlawfully influence the witness testimonies. She also considered that Mr. Thachi's actions show persistence in furthering obstruction efforts from within the detention facilities, including by leveraging his influence over former KLA affiliates loyal to him and persons from his political circles. She also referred to previous findings suggesting that, in the past, Mr. Thachi attempted to undermine the specialist chambers and, through his circles, offered benefits to persons who were summoned by the SPO to provide information to the SPO and the specialist chambers. The pretrial judge noted that the prosecution has closed its case in the Thachi et al. War crimes trial, but considered that the risk of obstructing witnesses and victims does not cease to exist since, 1, the proceedings in Mr. Thachi's war crimes trial remain ongoing, and the trial panel may hear further evidence from the participating victims, defense witnesses, and rebuttal witnesses, including by witnesses who may have already testified. And 2, a trial panel may, under exceptional circumstances, hear additional evidence after the closing of the case under Rule 136 of the rules. The pretrial judge also found that there is a risk of Mr. Thachi obstructing the course of justice in his separate case related to alleged witness tampering. That was all from me. If there are any questions, I'll be happy to respond.